Thanks, Ron, I guess. As Ron suggests and says, this is my first seminar with Fillion Wakely, Thorup Angeletti. And of course, I'm here right after Mr. Leach, the keynote speaker, which of course leads me to believe the selection process was something along the lines of get the new guy. And I note that I've been given an illustrious 15 minutes to speak, or as we call it, 0.25. I knew that would get this crowd. The other thing I do have to point out, it's just part of my nature, I have to recognize that this is a particularly important time of year when the world, and particularly those of us in North America, are treated to some of the great sporting events that the world has to offer. For those of us who weren't born here, who have parents who weren't born here, we're of course watching the World Cup. For those of us who we're all born and raised in Canada alone, I know many of you seem to think the World Cup is just Gary Bettman changing Stanley or taking Stanley off the Stanley Cup name. But you're watching the LA Kings and the New York Rangers treat us to some of the greatest hockey that's been played in the last little while. And of course, New York and Los Angeles are the biggest cities in America, so our American friends are of course watching basketball. Now, with my 4 minutes left, I'll take you through a few of the decisions and areas of the law that I think that have been helpful and useful for those of us who deal with the non-union side of things, and the decisions the courts have come up with in the last year or so. And they're sort of broken up into three different sectors and trends that I see having developed over the last couple of years. The first has to do with what a lot of lawyers, in particular on the plaintiff bar side, are calling extraordinary damages, that encompasses aggravated damages, moral damages, punitive damages, whatever you want to call it. The stuff that's unusual and over and above the usual severance payments that we're all used to dealing with. That's tied into, in many of the cases, harassment within the workplace. And those two things seem to be going together and have for the last couple of years. So that's topic number one. That ties into constructive dismissal and what the courts are doing with mitigation. And finally, I'll talk, and I know everybody will be thrilled about this, a little procedure, some courtroom procedure, which is always, really keen topic of discussion for the client community, but I'm going to raise it for you anyway because I think it's important. So the first area is, as I said, the extraordinary damages topic. What's been happening over the last few years in particular is we've seen historically the courts originally sort of shying away from the idea that they'd even want to deal with this kind of stuff. The Vorvis decision, some of you are familiar with from now 2 decades ago, where basically the court was saying, look, we're only going to award these sorts of things in very limited circumstances. That moved into Wallace in the late 90s, early 2000s, where the Supreme Court was saying, okay, what we're going to do is if there's what we call bad faith in the manner of dismissal, we're going to extend the notice period. So we're not going to give it as traditional extraordinary damages, aggravated damages, punitive damages. We're going to extend the notice period. That went on for a few years, and then Keys and Honda came along a couple of years ago, and they said, well, you know what, that's not working out so well. We don't like the way that's developing, so we're going to go back to the old idea of aggravated damages and punitive damages, and we're back to where we began. What's happened in the last couple of years, however, is a real move, in my view, a real move amongst the plaintiff bar in particular, the employee side of the bar, to try to expand and add to the types of conduct that these sorts of awards can be made, and more importantly, the amount of the awards that can be given by the courts. This is happening both in the judge alone trials and in particular in the jury trials. You're seeing a lot of awards coming out, well, not necessarily a lot, but these are the ones that are getting all the press. And one of those that has hit the newspaper again recently is the Boucher and Walmart case. So the Court of Appeal dealt with that. It's a 2012 original trial decision out of Windsor. And the Court of Appeal just released its decision a couple of weeks ago. So what happened in 2012 is Ms. Boucher was an employee, and she alleged significant harassment by her manager, and also said that she'd been punched in the arm twice by a coworker. Those were the claims that went through to trial. What's important to keep in mind about that is that Ms. Boucher also had a contract, and she had been paid out under that contract. So she'd already received what she was supposed to get in the event that she'd been dismissed. What she was saying is the treatment that she'd received was tantamount to a constructive dismissal. She'd been treated so poorly that she could walk away and still collect. The company was fine with paying her out. They, in fact, paid her out under her contract, but the trial went ahead just on the extraordinary damages. And the trial was in front of a jury, and the jury awarded, and it's listed in the paper for you, against the company $200,000 for intentional infliction of mental suffering, $1 million in punitive damages, and $10,000 for assault. And against the manager individually, on top of the damages awarded against the company, $100,000 for infliction of mental suffering and $150,000 for punitive damages. So we're talking, a seven-figure, $1.4 million total award. Not surprisingly, that was appealed, and it went up to the Court of Appeal, and as I said, the decision was issued a couple of weeks ago. What the court ultimately said was, when it comes to everything but the punitive damages side of it, we're going to defer to the jury. That's the jury's role. They are the ones that decide the seriousness and the amount of damage that was done. And so we're going to leave the infliction of mental suffering and the aggravated damages side of things, and that's going to stay the same because it's reasonable and justifiable. Unless the court feels that the jury's gone right off the deep end, they're going to allow whatever the jury decide to stand. What they did say, though, is punitive damages, that went too far. The idea, and this has long been the case, again, right back from when Vorvis first came out, punitive damages are meant to punish by the very name. And it's about punishing the company or the employer or employees, coworkers and supervisors for something that is so beyond the pale that it warrants punishment. It's not about compensating, it's about punishing. And that wasn't necessary in this case because the employee, Ms. Boucher, had been compensated reasonably, both in terms of the severance and in terms of the other amounts that had been awarded. And so the Court of Appeal knocked 90% off the punitive damages awards, both against the company and against the individual manager. But again, this is still, we're still talking a very significant award and some big damages, big money being awarded against the company and coworker in these, particularly in these supervisor subordinate kind of harassment cases. And we've seen that over the last couple of years. I referred to the 2006 decision, which is SULZ, S-U-L-Z. That's an RCMP officer who was harassed by her superior officer. There, the court in BC awarded more than $1 million to that individual. In Ontario, a couple of years ago in 2010, there was the Paris Ferreira and Ayot case, and the Ontario Court of Appeal stepped in again and reduced an award of more than $500,000 down to $150,000, but again, it originally had been up in that $500,000 mark. And even just in 2012, another jury in BC in Higginson and Babine Forest Products had awarded $800,000, again because of a hostile and quote-unquote miserable working environment when effectively the new owner had essentially forced the employee to resign. So these extra damages are becoming much more significant. They're becoming something that is commonly being requested, and they're not simply falling by the wayside as they typically used to. So don't be surprised, and some of you will have already received statements of claim suggesting that these kinds of awards are warranted, and you'll have to be dealing with them going forward. Moving on to a related case to a degree is Clark and Syncrude Canada. And I say it's related because it's sort of the flip side to the harassment harassment coin, where Boucher is about the employer's liability for that kind of activity. Clark is about the employer's ability to deal with the harasser. I also like to throw in at least one case where the employer has won. So this is my example this year. It's not an unusual, it's becoming less and less usual situation. It's basically Mr. Clark went on a bit of a bender at a function, got intoxicated and sexually harassed several women. The details are in the paper. I'm not going to go through them. It's outrageous in some respects and certainly inappropriate in all respects. But what the court did, and why I thought it was important to raise this particular case, was they said, look, this is a 22-year guy with an unblemished record. He's a fairly senior person, but we're still going to say this is just cause. Right? This kind of harassment is so unacceptable, so inappropriate, that we're still going to allow the company to deal with it as a just cause situation, even despite all the history and the context, which normally we say as the court, we expect the employer to take into account. It's still going to be that if you harass in that kind of way and to that kind of extent, the history, the person's individual context won't trump the employer's right to terminate. So there is a bit of a good news, bad news story on that side. Moving from the extraordinary damages and harassment side of things to the more constructive dismissal, I wanted to touch base on the Damaso and PSI Peripheral Solutions case. There, it's a bit unusual. We're all familiar with the constructive dismissal cases where the employer takes something away, right? That's the classic constructive dismissal. You take away a bonus, you move them to a different location, you take away something that they already hadn't entitled to, you do something to the negative. And that becomes a constructive dismissal. That's the classic definition. What makes the Damaso case a little different is rather than taking away, it was about adding to the employee's role. So and this is not unusual for many of you over the last few years, it's about doing more with less. And what happened was the company needed to consolidate. It did shed some jobs, but not this particular employee's. But what they did was took a role, an extra role, and added it to his plate. And I find it interesting, as is so often the case, that the first complaint was, you're giving me more work to do, but you're not paying me more. That sort of changed over time from, you're not paying me more, and you're giving me so much work to do that it's untenable. And that's my constructive dismissal, and I don't think that's appropriate, so I'm refusing to take that on. What's also a little different about this case is, rather than actually make Mr. Damaso do the role, the company said, fine, we won't make you do it, we'll hire an outside person to do that, but what we're going to do instead is give you 12 months of working notice. So you're done in a year, and we'll get somebody who will do all the role. So Mr. Damaso said, fine, that's still a constructive dismissal. I'm out the door, and I'm going to go to court. And ultimately, the court agreed with him. They said the fact that these additional duties had been added to his plate, contrary to his own wishes, he wasn't consenting to it, was a change to the terms of employment. It was a constructive dismissal. And he wasn't required to work out that 12-month notice period because it would have been unreasonable for him to do so, or unreasonable to require him to do so, simply because of the nature of the debate that had gone on between the parties. So again, I raised this one mostly because it's a situation I think a lot of you are facing. Certainly I've talked to several clients about it over the last few years. Just keep in mind that this is the kind of thing that you need to watch out for when you're trying to make these changes. There's also reference to the Farwell and Citer matter. It's another issue to do with mitigation. I won't go into the facts, but the one thing that I wanted to point out is the employer lost on the mitigation argument. This was a typical demotion, so moving somebody from a VP role back to his old role, constructive dismissal. And what the court said was, The problem with the mitigation argument in that case, so again, the employer said you should have taken on the old role anyway in mitigation. And what the court said was the problem with, it wasn't that that would have been demeaning, which is what they've done many times before, but the problem was that from a chronological standpoint, the company said, you're being demoted. The employee said, no, I've been constructively dismissed. Then he filed the claim. Then the company argued that he should have taken the old role. What they failed to do, according to the court, was offer him the job again. So basically the court was requiring that the employer say, okay, you rejected it once. We're now offering it to you again in mitigation so that you can reject it a second time. So just be careful and remember that if you're going to try and rely on that other role as an alternative and use it as a mitigation argument, you're going to have to offer it a second time or you risk this kind of result. And then finally, the highlight, the procedural argument. Over the last several years, there's been a bit of a change in terms of how the courts deal with summary judgment. The old rule was effectively, unless there's nothing for the court to hear a trial about, then we won't give you summary judgment. The rules changed in 2010 to try and broaden that out, make it a little easier for the court to decide a case based on a paper record, not to have an actual trial where witnesses come in. But the Court of Appeal in this province in 2011 issued a decision basically saying, you know what, even though the rules have changed, you still have to have, the trial judge still has to have a full and complete appreciation for the facts and the issues, and shouldn't be making a decision based on summary judgment unless everything is there. So again, the default is go to trial unless you don't need one. You don't need to hear in-person evidence. Just a few weeks ago, in January, in Herniak and Maudlin, the Supreme Court has effectively said to the public now, at least the Ontario public, because this is an Ontario case, that the default should be, in effect, summary judgment. So, and I've given you the actual wording that the court used, but what they've effectively done is promoted the idea of summary judgment as a way to resolve cases. They've essentially said, if you can decide on the basis of a summary judgment and you don't need a trial, if you can reasonably do that, then don't go to trial. Give the award. What that means is that we're going to be seeing a lot more of these kind of motions. It was already happening. I gave you 4 different decisions over the last few years that started when the rules changed in 2010. But I've already received 3 summary judgment motions in the last few months, particularly when it comes to notice. So if you're in a situation where you're debating how long the notice period should be, if that's really the debate, don't be surprised if summary judgment is the next step for the employee's lawyers if you can't come to a quick and simple deal. What that also means is the tactic of waiting and seeing whether somebody gets a new job and whether they mitigate to reduce the amount you have to pay isn't going to work, because you can get to a summary judgment, except in a few courts like Brampton and Newmarket, which are a little slower. You can get to summary judgment within a couple of months. And the court's not going to, and they've been pretty clear about this, they're not going to wait. They're not going to wait and see. They're not going to say to the parties, okay, our notice period is 16 months, let's wait and see whether the person gets a new job in that 16-month time frame. They're not. They're going to make their decision, and they've made some creative ways of dealing with the potential that somebody finds a new job. But they're not shy about simply making the decision and saying, here it is, that's it, and you're done. So be prepared that that's what's going to happen. It's going to be, it's already started, and it will happen more frequently. What's going to be interesting is whether it moves from just the notice cases to other situations as well. It'll be a little harder when there's some actual facts to debate, and some, particularly if there's going to be some in-person testimony and conflicting evidence in that respect. But again, the court's effectively saying, you, the trial judges, should be making the decisions if you can.